Law. This is week 6 of term 3, 2019. And given this is Christmas week, we're not having a live session. This is the recorded session that would normally take place on a Tuesday evening, which this year is Christmas Eve. So tonight we're dealing with strategic environmental planning and assessment. In other words, planning law in Queensland in a nutshell. Now, of course, the content of tonight's discussion, the work that we do this week, could easily be the subject of an entire unit. Planning is a huge process, but of course fundamentally important when studying the issue of environmental law. In other words, we can't really identify how environmental law works unless we know how strategic planning works and the assessment process works. What that means is that tonight we're dealing with a combination of looking at legislation primarily and regulatory bodies from a practical perspective. That is the assessment component of the work that we're doing this week. So there's not much by way of case law that I'm going to talk to you about tonight, but I will talk to you about the Planning Act 2016 Queensland, and I'll introduce you to some of the online resources available through the Queensland Government as part of the Queensland's planning system. Now, to supplement the material that you have in the notes and that we're going to talk about tonight, I'll recommend a very good textbook. It's called Planning in Queensland, Law, Policy and Practice. It's by Philippa England and it's through the Federation Press. That's the latest version of this textbook, which, as I said, is very useful. One of the things I like about it is that it's quite practical in its application. So tonight will be essentially a practical session. Last week, we dealt with an introduction to legislation that deals with environmental law and ecological development from a general perspective. So this week we deal more with statutory instruments and we deal with regulatory tools in the context of what we discussed last week in the concept of ecologically sustainable development. So this week, of course, we're planning on dealing with the nuts and bolts, as it were. So we're concentrating on planning law in Queensland. What that means is that we're looking at how developments are assessed, what are some of the issues that are taken into account, and we'll do that from a perspective of strategic environmental planning, but there will be an element of development control in what we discuss. So, of course, the key legislation is the Planning Act. As we proceed, I'll invite you to call that up on your screens and do have a look at that. The Planning Act Queensland was enacted in 2016. It's the key piece of legislation. It replaces the Sustainable Planning Act, and I will refer to the Sustainable Planning Act from time to time because it's quite a recent changeover still. But the Planning Act provides detail about the management and the process by which development occurs. Of course, there is involvement primarily through the state, but also through regional councils. Therefore, local planning documentation is important, and it's important to understand how that's implemented in a practical sense. The developments as they were being processed prior to 2016 were through the Integrated Development Assessment System. And for that, have a look at Section 230 of the Sustainable Planning Act 2009. As I said, the key legislation for tonight is the Planning Act. So what we're looking at is trying to integrate the legal system with environmental law in the component of planning law. And what that means is that we need to be mindful of the role of Parliament and the executive as well as the judiciary. So a big emphasis tonight on the executive component. Of course, just as a refresher, the Parliament makes legislation and it's the executive that implements the legislation in a workable manner, regulates the way in which the development applications take place, and then, of course, have some role in enforcement and prosecution. When it gets to court, the judiciary have a role to play. Of course, the judiciary consider legislation, the judiciary considers previous case law, but ultimately comes to a decision in relation to each case on its merits. So many of the cases that you'll read about where development application decisions have been challenged are merits review cases. The key area of practice in Queensland for legislation, for case law, is through the Planning and Environment Court, and from a practical perspective, relevant to what we're talking about tonight, to a lesser degree, the Land Court. In Victoria, the Victorian Civil and Administrative Tribunal, VCAT, has a considerable role to play in the implementation of environmental law. That's not the case in Queensland, at least not at this stage. That may change in the future. So when you're undertaking your reading, look out for Planning and Environment Court cases primarily in Queensland, and Planning and Environment Court judges are constituted by essentially district court judges who have a commission to hear P&E matters, as we call it. In Victoria, if you're looking at comparable cases, odds are you'll be looking at VCAT decisions. So, of course, Parliament creates the documentation, the laws, and delegates power to regional and local planning authorities to make documents that are planning documents, and will set the policies. And when we talk about planning documents, we'll be talking about state planning policy and so on that we'll deal with tonight. So when you think about the policy documentation that's implemented, bear in mind the general principle that it's part of delegated legislation. And as a result of that, the first thing that you'd always consider if you're challenging is whether the delegated authority was used properly to create the particular document in place. For the most part, it will be, but that's not always going to be the case. Now, members of the public who are unhappy with what is happening in terms of developments have a role to play. So when it comes to the making of planning and environment-based decisions, members of the public can become involved, and become involved at three levels. So the first is that the member of the public might be unhappy with the general legislation, such as the Planning Act, or it might be legislation of specific effect, such as Century Code Development Act. So at a parliamentary level, the remedy is to lobby and seek change at time of election. It's not possible for an individual or a group or a collective to challenge what Parliament introduced by way of legislation. But if they're unhappy, if people are unhappy with the way in which planning schemes are developed and brought into effect, which is at an executive level, it's not, again, possible to challenge the planning schemes at that stage, but they can lobby against the introduction of planning schemes, but have no right to appeal a council's election to approve a planning scheme. Again, these are ramifications at the time of election. However, when it comes to the making of individual decisions, through the executive, typically made by an assessment manager, in relation to those decisions where there's an impact assessable development application, the matter may be challenged and the matter may then be determined by the judiciary. So if you're representing, or asked to represent, as it were, members of the public or an individual, just ask yourself whether you have the right to launch the challenge. So there are issues around standing that we'll talk about later in the unit, but bear in mind that it's at that level of the actual decision making rather than the higher level legislation and planning documentation that members of the public can become involved. It's not to say that the documentation created by planning authorities cannot be the subject of litigation. They can, but in this sense. So if an individual is not happy with a certain decision, then one of the arguments that they might make is that the decision that was made conflicts with the planning scheme or the planning documentation. So it will be relevant in that sense, but it's not relevant in terms of a direct challenge to the passing of that material. So just a few words about the Planning and Environment Court. I mentioned that the P&E Court is available to hear cases where people are unhappy with the results of environmental decisions. But it's not every decision made by every assessment manager that can become the subject of court proceedings. In general terms, to become the subject of litigation, the development application in question must be an impact assessable development. So when you're undertaking your work and considering it, and you're seeking to challenge a development application, just bear in mind that there is that preliminary question that might need to be considered. Now, the Planning and Environment Court was set up under the Planning and Environment Court Act, also 2016, the same year that the Planning Act was enacted. And that Act, the P&E Court Act and the Planning Act as well, set out the matters by which the court can hear matters, including the rights of appeal. There is also the Development Tribunal, and this was set up by the Planning Act 2016. Now, when a matter does go to the Planning and Environment Court, it considers the development decision as what we call a merits appeal, meaning that the court, as it were, steps into the shoes of the decision maker to make what we call the correct and preferable decision in relation to the matter. And the way in which the court does that is it hears the matter afresh. It's there sitting in the shoes of the assessment manager. It comes up with a fresh decision. It's therefore charged with the responsibility of determining the application on its merits. That is, on its merits at the day that the court is hearing the matter, not when the assessment manager first heard the matter and made a decision. In other words, it's not for the court to focus on the decision-making process of the assessment manager, which is what would happen in a judicial appeal, but it's a matter of essentially the court becoming the assessment manager through the merits appeal process. Soon I'll show you some of the online resources, but you'll see reference to the State Assessment and Referral Agency, which has an interest to play in assessing applications where there's a state interest. And it may be that the state has an interest as a result of specification in a planning regulation or a state planning instrument. So state planning instruments set out what the state government has identified as critical, non-negotiable planning matters. And there are two state planning instruments. There are the state planning policies, or the state planning policy, and there are regional plans. So let's now start to look at the website for the Queensland Government, and hopefully this will start to make a little more sense. I'll share the screen, and with luck, we'll be looking at the state planning policy. It's not showing up on my screen, but hopefully that's what you're seeing. So the state planning policy is part of the Queensland Government Queensland Planning Scheme, and state planning policy is something that sets out the state's interest in land use planning and development across Queensland, and it applies when council is making or amending their local planning instruments. So you can see the state planning policy, the most recent offering of that from 2017, in a downloadable PDF. The state planning policy is important because it ensures the state's interests are maintained in planning and are protected. So I mentioned that the documents that are prepared at a planning level are basically done by councils as a result of delegated legislation. But having the state planning policy means that the state maintains an interest in the way that planning is undertaken at a state level. And you'll see on the web page, which is planning.dsd.mip.qld.gov.au/plannings/state-planning/state-planning-policy-SPP, just in case you can't see the screen that I have up on the board. But you'll see that on that web page there are 17 state interests arranged under 5 broad themes, and you can learn more about the SPP and the way in which it works as if you read the guidance material that is available on that page. Now, at the second type of state planning instrument behind and sits below the state planning policy are regional plans. And regional plans are also accessible through Queensland's planning system website. And you'll see that there are current plans in relation to Cape York 2014 through to Wide Bay Burnett 2011 and areas elsewhere around the state. And the plan dates vary from 2009 through to 2017. And you'll see there's reference there to the relevant legislation, the key legislation, the Planning Act 2016, but also consider in particular the Planning Regulation 2017. So the idea of the regional planning documentation is to strike a balance between protecting priority land uses and delivering a diverse and prosperous economic future for regions. So regional plans make up the second of the planning instruments at a state level. Below that, we have the local planning instruments. And the local planning instruments are those that are made by local governments in consultation with their communities. So I mentioned that you can't challenge these documents once they're made, but the legislation requires local planners to consult with the community and take into account not only the interests of the community, but importantly, to take into account the state planning interests. And that's as a result of implementing the overriding rules, if you like, of the 2 state planning instruments. So when it comes to local planning instruments, there are 3. They are planning schemes, temporary local planning instruments, and planning scheme policies. So essentially we've got 5 levels of planning instruments. 2 levels for the state planning policy and the regional plans, and below that the 3 statutory local planning instruments, planning schemes, temporary local planning schemes, and planning scheme policies. If we look at another page on Queensland's planning system, we'll see a guide to resources. Now, this is pretty useful from a practical perspective, and of course it's searchable. There are many of the resources that are available that may assist in particular circumstances. So I would recommend that you just spend some time looking through the resources section and getting a feel for what's there and asking yourself whether any of these might be of use down the track. On the web page, there's some valuable information that might assist you, and you see the resources link that I've got is towards the top, the right-hand side of the top ribbon. Now, there is some other resources that relate to guidance issues, and one of those is under the heading of resources, guidance for applying the regulated requirements to local planning schemes, and that's in PDF and Word version. Another that might be useful, depending on the circumstances, are the state interest guiding material, and you see there the state planning policy guidance in relation to specific areas. So if you're dealing with an environmental law question and there's a particular emphasis on, for example, biodiversity or water quality, whatever it might be, then having reference to the state planning policy guidance documents, which are intended to guide people from a practical perspective, could be useful. I mentioned earlier the planning regulation. Do have a look at that, perhaps bookmark it, but certainly get a feel for it in the planning regulations from 2017. What it does is, and I'm not showing this on the screen, but it's available, of course, through OSLI and through wherever it is that you find your regulations generally, but the planning regulation 2017 states which entity is responsible for assessing and then deciding an application. The entity is referred to as the assessment manager. And usually the assessment manager is employed by a local authority. Some applications also require additional assessment by state governments or other entities, and you'll hear of those referred to as referral agencies. So it may be, for example, that a local authority is the assessment manager and is assessing the overall application, but there's one aspect of it, or maybe more than one aspect, which is to be undertaken through an assessment separately by state government or some other entity, and that's a referral agency. So keep that in mind and be mindful of the involvement of third parties in that sense. From a practical perspective then, we need to consider how planning and development assessment is made under the Planning Act. Here we have, through the Department of Transport and Main Roads, an example of how planning and development assessment is undertaken under the Act, but from the perspective of the Department of Transport and Main Roads. Essentially, the development is referred to the state for assessment, and the state, when it's a state assessable matter, must consider the impacts of the development, for example, on state transport. Now, the planning process itself is undertaken typically through councils, but on this page, and hopefully it's still showing on your screen, if not, it's planning.dsdmip.qld.gov.au. Here we have Queensland's planning system. And we've already looked at this page. You'll see at the top, the ribbon shows resources, and on the right-hand side, and our planning system on the left. But now I want to show you more about the practical aspect of the development process. So before I start to show you the online tools and services, just a quick word about development applications. There are essentially different types. And over the years, with the introduction of the Integrated Planning Act, the Sustainable Planning Act, and now the Planning Act, the types of applications and the terminology has changed. But the basic rule now under the Planning Act 2016 is that all development is accepted development unless it's been identified as accessible development or prohibited development. Now, when it's an accessible development application, or when a development is accessible rather, an application and an assessment is required. And the development assessment rules set out the process for how that development is assessed. Now, when it comes to the planning system in Queensland, the Queensland Government has developed an excellent online platform that explains the planning process. We've looked at quite a few of those things this evening, but I'd urge you to look at this website, spend some time and bookmark that which you believe to be important. But the website is instructive in terms of providing hands-on information, particularly in relation to the online tools and services. So if we click on the right-hand side, the link for online tools and services, you'll see a number of interactive aspects. Do have a look at that. Get a feel for the way in which it works in a practical sense. Have a look at some of the forms, the development application forms. You'll be guided by looking at the form as to those things that are regarded as relevant and get some idea of what's accessible and what's not. One thing you can do is pretend for a moment that you're a property developer and map your development application. So on the right-hand side, there's a further link, map your development application. If we click on that, you'll see that a series of questions come up on the screen. But before you start answering the questions in hypothetical sense, read the commentary because it reinforces what type of development we're talking about. So under the Planning Act, all development is accepted development unless it's been identified as accessible or prohibited, as I mentioned earlier. So now we can see a flowchart by answering these questions. Let's take a hypothetical run. Is your proposal accepted or prohibited? Let's say it's not. Is the application required to be publicly notified? Let's say yes. And what I'd urge you to do is, as you complete this task, you'll see, well, these are the important parameters, these are the important questions. Have a look at the Planning Act and have a look at the planning regulations to see where these questions are considered as part of the legislation. Will the application involve referral to a referral agency? I mentioned earlier that that often is the case. Let's say yes. Do you intend to elect not to receive an information request? Let's say no to that one. Is the application likely to involve an information request? Let's say yes. And from that, we'll view the flowchart. So this flowchart gives you an idea of how things work in a practical sense and shows the number of business days. Now on your screen, that's probably going to be too small, although that might help things. You'll see on the left-hand side that in an impact accessible development application, which involves referral, information request and public notification, being the variables that we ticked, there are 5 parts to the process. On the far left side, you'll see that part 1 deals with the application. The application is lodged, and we know where to get that application forms because that's one of the resources that are available on this website. The application is then lodged, and either the assessment manager gives an action notice or the assessment manager gives confirmation notice. And what I'd recommend is that when you get to these steps, have a look at the Act, look at the regulations, get a feel for where they fit in so that you can tie this practical flowchart in with the legislation and the legislative requirements. You'll see at the top that there are a number of business days allocated for each step to take place. And the timeframes can be extended. That can be done by agreement. But it should be the case that the application is dealt with in accordance with the timeframes to keep it all moving. The second stage is the referral process. The second stage includes part 3, which is the information request. Then we have public notifications is stage 4, and stage 5 is the decision. So if you accumulate those business days, you'll get an idea of how long this particular application should take in order to be processed. I'll stop the share now, and indeed I'll stop for this week. So thank you very much for your patience. I know it might sound a bit dry, the whole process of planning and development application, but of course it's critically important. So when you're dealing with the environmental law issues, you need to know the structure, the way in which it works in a practical sense. So that's the planning material, and I hope that tonight's material has been of some assistance to you. Enjoy your Christmas break, and we'll see you not next week, but the week after that, and into week 7. All the best. Bye for now.